everybody. My name is Noam Dolgin. Thank you for joining us for Understanding Partnership Agreements. This is the first of the CoHo BC's 2021 speaker series. And I'll talk a little bit about what is CoHo and what we're looking to do. And then we'll get into Daleep's presentation. So first off, I want to thank everyone for joining us this evening. And of course, to Daleep for coming in and being willing to present to us. So thank you all so much for joining us on this evening. So CoHo BC, hold on a second, make sure everyone gets in here. Fantastic. All right. What is CoHo BC? So CoHo BC is a group that's working to promote co-ownership as a viable housing option in BC and particularly in the Greater Vancouver area. We provide resources and professional support to assist groups going through the co-ownership process. We assist in the creation of ownership groups through a dating pool, and I'll talk more about that later, and a chance to meet other like-minded individuals. And we help facilitate the resale of shared property and interests and such along the way. We came together as a group. Every time I let somebody in, it makes my slides, okay. There we go. Whoa, too far. We came together as a group of professionals who had experience with co-ownership and had been seeing this as a growing part of the market. People, myself as a realtor, as well as lawyers like Daleep here, builders, financial institutions, architects, therapists, all sorts of folks throughout the real estate and the housing industry who saw that community, affordability, and solid housing is key, and that through collaboration and through co-ownership, you can really make that happen. So we were people who've been seeing this happen with our own clients, and we decided to come together and see if we could create an organization that would help promote this more widely as a viable option, not just something that a few people are doing here and a few people are doing there. So about myself, my name again is Noam Dolgin. I work as a realtor with a focus on sustainable real estate services, by which I mean really thinking for real homes for real people about their triple bottom line, their economic sustainability, their social sustainability, and their environmental sustainability. So through that kind of mindset, looking at housing, co-ownership became an obvious choice for many of my clients and for myself as well. By having higher density, you create more affordability. I hate to say anything is affordable in Vancouver, but better affordability. You certainly create community built into your housing network, and you are living a more sustainable home existence. I also work in other forms of green homes, first-time buyers, families, generally just real homes for real people. I'm an outside-the-box real estate thinker, looking at how to create value and community for people. Before going into real estate, my background was in environmental education and institutional greening, and also community engagement and development. So these values were natural, in the work. So what is real estate co-ownership? And there's a much larger, thorough presentation that I give on this topic. Hopefully many of you have been to it in the past. If you haven't, we'll have another one coming up in a few weeks' time. If you want to go more in depth of all the different forms and the valuations and pricing and all the nuances. But I'll just do a quick introduction to co-ownership and then hand the floor over to Daleep. So co-ownership is nothing new. It's just two or more individuals or groups buying property together. And it's been happening forever. Before 1966, there was no Strata Act in BC. People owned shares in buildings. If you owned buildings at all, like apartments at all, families would own together, but there was no real way of stratifying or of owning separate units. In the 70s, ownership co-ops popped up, and we still have some of those across the city. From the 90s to present, we have a movement called co-housing. And throughout this time, people have been buying homes with friends, with family, to take advantage of what the housing market has and financial opportunities. Co-ownership also happens traditionally in a number of other forms: investment co-ownership, families I talked about, and vacation timeshares, etc. So co-ownership is nothing new, but the idea of two families co-owning a home and occupying it at the same time is definitely growing in popularity in general over the last decades, and particularly now in this time. And of course, all stratified condos, co-ops, duplexes are co-owned to some degree. And even if you own your property outright, you do have neighbors. You don't. You are tied to other people. So one of the advantages here is some of those people going into it, and you can alleviate some of those challenges. So why co-own? People co-own to build community, to get mutual support systems from each other. They co-own because they get more for their money. That's one of the major reasons. They co-own because they can live in otherwise unavailable locations. So, for example, a laneway house in a single family neighborhood, you can't generally buy in the market outright, but you can own that in a co-ownership situation. And to know your neighbors before you buy, being a big one, to really have those relationships going forward. Who do we see co-owning primarily? A lot of intergenerational families. So again, parents with kids at different stages in life. So maybe parents investing in their kids' first property, or parents building a laneway house and the kid living back there when they're a young adult and when they're a young couple, and then later in life swapping when they have a family where the senior members live in the laneway house and the young couple live in the main house. We see two families, friends, or even strangers sharing homes. So Vancouver Specials being a classic example, but non-stratified duplexes and other forms where they'd each have their own suites, but they could be next to each other and help look after each other and share resources. You see first-time home buyers and condo buyers trying to get into the market who realize they can get more affordability by sharing a 2-bedroom or a townhouse than by buying a 1-bedroom suite. Downsizers and older adults who want community and who don't need the same space, and people who want to live collectively for a variety of reasons. Investors and anyone who can think outside the box. So this is really something that works for a lot of different people for a lot of different reasons. And there are many examples of what it looks like. I mean, I've referred to things like vacation properties or investment properties where you can have just a basic rental property that you co-own. But for co-living situations, the most common in Vancouver, especially examples are, I mentioned a Vancouver Special. If you don't know what those are, look them up. But basically, they're designed for 2 full family units, usually 3 bedrooms, 1,000 to 1,400 square feet per floor. And so 2 families can share those at a 30% discount from what it would cost to buy kind of a similar half duplex. You see main house, garden suite, and laneway house shared by 2 or 3 families. You see communal living situations where 2 to 5 adults share a house or a condo, and they each have maybe their own floor or their own space and bathroom, but they share a living room and kitchen. And you see multi-suited homes, 3 to 5 family, older homes converted. You also see co-development and community co-housing and other forms of community ownership happening on a larger scale. CoHo specializes mainly in the smaller scale, the housing hack to kind of work within the single family zoning, get the affordability that comes with that, get the timeline and the ability to do something quickly with just 1 or 2 people. But there's definitely other models to look at larger development and community sizes as well. How much to share? This is something that people want to ask, right? So a lot of folks, you can decide to share just the land and the ownership structure, but everyone has their own private suite, their private kitchen, their private bathroom. So that's a house like the Vancouver Special, or a multi-suited home, the house in the laneway house. Or you can choose to live collectively with a shared kitchen, bathroom, living spaces, etc. That clearly creates the most affordability, the most community, but has certain strings that come along with that as well. So the advantages of co-ownership: know your neighbors, get community and support, save money, get more space, share resources, higher quality of housing otherwise not otherwise available, financial synergy where basically you guys can come together and qualify for more than you would independently, and triple bottom line sustainability, right? Social, fiscal, and environmental sustainable living. There are challenges associated with this, and this is where Daleep comes in, because There are some limitations and some challenges, legal and social, that you want to address. But by having a good partnership agreement and a good deliberative process before you get into buy, you really can address most of these in advance. And that's really where CoHo comes out. I myself, as a realtor, but I can help guide you through the deliberative process. I can help you find what housing might work, help you address some of the questions you might want. And again, we have other professionals if you're going to build together, if you want to see a couples counselor before you even start, and of course, Daleep, who's key. Having a lawyer with experience in partnership agreements is key. And the reason for this is the challenges. So the two big challenges are financial, and that is that on a property in Vancouver, you all have to be on title and on the mortgage together, almost always. There are some legal loopholes if you do corporations, things like that, but generally everyone's on title and on the mortgage. And that means you have to have a good legal agreement to protect yourself and your interest in relation to your partner. And the second challenge is an exit strategy. Because when you're buying your primary residence, you want to know that A, you're not going to be forced to sell after 6 months or quickly in a month's notice, because your partner wants to move to Toronto. At the same time, at some point, you might upsize, you might downsize, you might move, you might die. You may need to transition out of this relationship. And so you need to have an effective exit strategy, and that needs to be deliberately thought of in advance and put down in a partnership agreement. As I can tell you, as a realtor, I see all the time these old agreements from the 70s and 80s. If they were really thoughtful in advance and they came to an agreement and they signed documentation, they can leave and effectively. They can either sell off the share of their property, either through MLS or privately through someone like me, or they can create a fair value for their property. But the ones that don't have good agreements end up fighting through court, end up tied up, and end up being a real challenge for both parties down the road. So definitely, having a solid agreement, and Daleep will go through all the things that go into it, not just the exit strategy, not just the mortgage and protection. How do you deal with ongoing disagreements? How do you find the right partner and have the questions in advance? But the last thing I'll just say before I hand it over is that at CoHo, we like to refer to it as a marriage, right? This is a long-term commitment, an intimate financial and housing and emotional commitment with somebody. But it's a marriage is going to end at a certain point, and you need to plan for that with an effective prenuptial agreement. And that's, again, where this partnership agreement is. And through an effective dating and engagement process, dating the properties, getting to know what's out there so you get the right property in the first time, and dating partners, understanding the pros and cons of different people, and who would make a good partner, who has the same timelines and goals, etc. Before you get into the marriage stage. So that's a little bit of background in what is co-ownership. I'll be able to take questions about that at the end. And as I said, we do have a much longer presentation on that, and a whole series of resources, an online guide on the CoHo website that explains much of what it's all about. And I can also be available to you. I'll talk about that later. But the key to any good co-ownership arrangement, whether it be co-investment or a cohabitation or any other form, is to have your legal ducks in a row, to have your big conversations first. And that's where having a good lawyer with lots of experience who's done this before. Any lawyer can draft up a partnership agreement, but they don't know the right questions to ask, then you're the one who's going to suffer down the road when the problems come up. So you want someone who's dealt with this before, and that's why we have people like Daleep and the Segev team on board. So at this point, I'm going to hand the floor over to you, Daleep, and thank you all very much for your patience listening to my basic overview, and now the main course that you all came for.
Right, hello, thanks for that introduction, Noam. So yes, my name is Daleep Aujlay. I'm an associate here at Segev LLP, and we're a law firm based out of Vancouver here. So just a little introduction about the firm, about who we are. So we're a full service firm, and so we have a wide area of practice, but our main focus is our real estate, residential, real estate, commercial. I also work with wills and estate, general business and technology. And then we also have lawyers here that specialize in hospitality, regulated industries, and corporate finance and securities. So who our clients are landowners, people planning to purchase property, tenants, and then all the way from entrepreneurs, investors to family businesses, and even startup business. So we serve a wide range of clientele. So getting into today's topic, here's just a brief overview of what I'm going to touch on today. So real quick, who should have a co-ownership agreement? What is a co-ownership agreement? What are some items to consider? And then within items to consider fall in management of the property, restrictions and remedies, which I will go into a little bit more detail than some of the other items. And then I can answer any questions that you may have. So there's different types. So you'll hear partnership agreement, you hear a cohabitation agreement, you'll hear co-ownership agreement. The title of the agreement doesn't really matter here. What matters is what's in the agreement. So there's, as Noam had touched on, there's different ways to purchase property within going on your own. So you can buy property that you're going to use for investment. So you can partner up with another individual or individuals, and those are properties that you're not going to yourself live in, and then how those will be dealt with. And then we have these agreements where you're actually going to reside in the property. And then those vary quite a bit from the previous situation I just touched on. And on top of that, you may have a amalgamation of the both, where you may have three individuals getting into a purchase of a property or two, but one of the individuals is actually going to be using as investment, and the other two are going to live in. So you can have a wide variety. But so who should have a co-ownership agreement? Essentially, it's as simple as anyone who's not in a marriage-like relationship needs an agreement. What is a marriage-like relationship? Well, it's essentially couples who live together for 2 years. And what's important here is they have the same rights as married couples when it comes to taxes, debts, and assets. Another entity that looks into marriage-like relationships is CRA. So if you have a cohabitation, or so you are cohabitating, and perhaps it's the scenario where you all reside in one unit and you share the kitchen and you share the living space, we have separate bedrooms, or even if you do have different suites, CRA may mistakenly consider you to be in a common law relationship. So it's important to have this agreement out there so you can use it as evidence that that isn't the situation here, that you actually are not in a marriage-like relationship. So that's important to touch on. So really anyone who's not in that type of relationship needs one of these agreements. So what is a co-ownership agreement? It's an agreement that governs your relationship and protects your interests. So really what it means is each co-owner has the right to possess the property and to use the property regardless of the percentage of their ownership. So if I had put in 30% into the purchase of a property and the other party put in 70, I still have all the same rights here. So you may need to cover that in the agreement with respect to how that works. Also, if there is no agreement, there's liability. So co-owners are not responsible for each other's debt and don't act on behalf unless it's provided in an agreement. There's limited obligations to other co-owners unless it's in the agreement. And especially if you're buying this property for investment purposes and you're not living in it, then you'll want to make sure you're not deemed a partnership arrangement, because there could be added tax liability there, which we're not going to get into today. But if you are purchasing with another party or two parties and it's a pure investment, you're not residing in it, That's also another consideration that you need to take, and that would be covered in this agreement. So that's why you have these agreements to cover off these issues. So essentially, you need this in essence because without a co-ownership agreement, each co-owner has the freedom to deal with their share of the property, their undivided interest, as they wish. So it's important to have these agreements in place. So an example of something I could do is if I and another party have bought a Vancouver special, I live downstairs, the other party lives upstairs. If we don't have an agreement, I could decide, you know what, I'm just going to Airbnb this place out. And there's going to be no restrictions on who I Airbnb, and it ends up becoming a destination for party goers. So you need an agreement here to make sure that's not going to happen. Okay. So some items to consider we have here is, excuse me, each owner typically is required to make a contribution towards the purchase. And typically if a party puts in half each, they tend to own 50% interest of the property. So property is typically owned on title in two different ways. You have what's called tenants in common, and you have what's called joint tenancy. In our situations here, we almost 100% of the time see the ownership in what's called tenants in common. The two differences between tenants in common and joint tenancy you'll have here is joint tenancy has the what's called a right of survivorship. So if one joint tenant passes away, their interest automatically passes on to the other joint tenant. This is an arrangement that you normally see between spouses when they buy a property. Tenants in common, the difference is if you have two parties and a party passes away, their interest is divided from the other party's interest, and then therefore it doesn't the other party doesn't transfer to them, it would fall into my estate. So that's why we have usually what's tenants in common, and then normally the ownership percentages reflect the amount of capital contribution. And then another item to consider once again is the use of the property, which I kind of touched on already. Is this an investment or rental property you're going to rent out? Are you going to reside in it, or is it going to be a mix of those? It's also important to take into consideration how really the property is going to be used. For example, am I going to run a home business out of the property? So am I going to have people coming in and out all the time? Am I going to have customers parking in the driveway? Am I going to have people park outside on the front of the property? So these are all considerations that need to be thought about about the use of the property. And then that's where Noam and myself, we come and we ask these questions, and we are able to structure the agreement accordingly. So we make sure everything's agreed to before you get into this purchase. And then we have management of the property, restriction and remedies. And I'm going to go into a little bit more detail on these three topics, and they have their own slides. So we can move on to the management of the property here. So management of the property, the first item here to consider is use of a third-party management company. Now, this would be relevant more so in the case of an investment property, one that you're renting out or you're leasing out. You may have a management company take care of running the property, collecting the rent, dealing with the tenants. But here, I just wanted to raise that, but here we're talking a little bit more about if you're residing. So things you'll want to consider is the respective roles of the co-owners. So what I mean by that is, you're, like Norman mentioned, all the parties here are on the mortgage. You're going to have bills coming in. For example, the internet service. Typically, you're going to have one internet service coming to the property. You're not going to have different suites typically getting different services. So who's in charge? Who's going to pay the bills? How's that's going to work? So that there is an example. Storage. This tends to come up if it's not set out in the agreement. We've had issues here where how the storage in the shed's going to work between the different parties, how storage in the garage going to work, how just storage anywhere, how much storage each party gets, or what what part of the shed, who gets what. So these are items that we can consider when you're coming to an agreement amongst all the parties, whether this is going to be bought between two parties or three or four. This is the storage comes up. Yard usage is another one. Unless it's set out, no party has more of a right than any other party to use the yard, but you may want to have private access to the yard certain amount of times a month, certain amount of times a week, if there's a hot tub, patio. These are all items that we can discuss and come to an arrangement with when we are drafting this cohabitation agreement amongst the parties. Parking is an important one as well. Access to the garage, how many cars, where on the driveway is usually a good idea to park, but it's also what sometimes, and what we rarely, sometimes we often see missed in an agreement like this is, what about guests? Where do they park? If I'm someone who's constantly having guests over and they're parking in the driveway, and let's say I buy a place with Noam, he can't get into the garage to park his car, or there's always cars in the way, it can become an issue. And the purpose of this agreement here is to ensure that the relationship between the parties doesn't get tarnished. And typically, whenever we meet clients who have been living in this type of arrangement down the road, there's a trigger event, and it tends to be quite small. It could be over me parking on the wrong side of the driveway, and then it just snowballs and it gets bigger and bigger and bigger to the part where now a lawyer like myself is involved with respect to moving forward with the ownership of the property. So it's important, even though these things may seem minor, it's important to cover them off in an agreement, because you don't want to have what I just call like a small triggering event and like a catalyst that'll spark the fire. Short-term rental, this is really important in today's, where we have Airbnb, VRBO. How does that work? Is that even going to be an option? If it is, are we going to have an age restriction on who can rent the property, months that can be rented out? This is common. This is common from clients that tend to perhaps travel for work, and they know their unit is going to be, or their bedroom's going to be empty for a couple weeks a month, or certain months of the year, or sporadically. They want to be able to make some income, so they want to take advantage of Airbnb or other companies like it. So it's very important to have that in there, whether you can or cannot, and if you can, what are the parameters surrounding this? Codes of conduct, noise, garbage, and recycling, they kind of all tie together, and it's kind of self-explanatory, especially with noise, restrictions on time, when you could have noise. So maybe, if it's outside, from 11 p.m. to 7 a.m., you may have some arrangement with respect to playing music at a certain volume. So these are all items that we'll consider once again, how garbage is going to be dealt with, how it's going to be taken out. And these are items that we sit with our clients, we raise, and these are just some of the ones that we typically come up with that clients haven't thought of. There's still a slew of other items that we touch on, but these are just some that I wanted to point out to you, that this is an area you're going to. These are things that will need to be considered. And then we have maintenance and repair. This is a big one, and a lot of where I can see Noam smiling there, he understands. This is an area of contention. So it's important to set out how decisions are going to be made with respect to all of these items, but especially maintenance and repair. And this is relevant if you have divided the property into multiple suites, or you have the laneway home and the main home. or you are sharing the space and you have the common area. So, this could be large upgrades. For example, the roof needs to be replaced. Well, how do you make this decision? Is this something that needs to be unanimous? If you have more than two owners, you have a couple owners, a handful, do you need a majority? What I mean on the slide by special majority could be, 2/3, 3/4, whatever you want to set. And um, these agreements are important on how these decisions are going to be made. Oftentimes, it'll be staggered. So you could say anything over something on the house is going to cost over $20,000. It needs to be unanimous. So let's say you have three parties owning the property, or four, or you could say 10 to 20. You need majority or special majority, and then under 10, you need a certain amount. And then we would highlight what are not only dollar amount, but you could also say certain types of improvements that would fall under what category and what threshold you need. These are important because it makes it very clear on how the property is going to be managed and how you're going to make these decisions. Because if it's not set out, it leads to disputes. And there are, especially when you have only two owners, deadlock is a big issue. It can happen. So that's where we work with the parties, and we come up with a system that would work in solving any deadlock issues. And we'll customize them to depending on the client's priorities and how we would work things out. Okay, so those are some items to consider. There's a lot more on top of that. Some people will talk about internet access, TV. A lot of people don't want TV cables. So how's that going to work? Telephone. I have a home business. I need to use Zoom all the time. Well, I need more bandwidth than someone who won't. So those are items to consider and account for. Okay. So also here we have restrictions on the property. These restrictions that you'll want these are important because once again, it will help make sure the ownership of the property runs smoothly. One of the restrictions I just had touched on earlier was Airbnb, or short-term rentals, or just rentals in general. Is that going to be an option? So can I, if I decide within a year or 2 years, I want to move, but I'm not interested in selling my share, can I lease my unit out? And it's not as simple as yes or no. It could be yes, but with approval of the other parties who own the property. So they, acting reasonably, get to have a say on who's going to be moving in on the property. And the restrictions, if you are going to say yes to the lease, you could have restrictions on the age of the individual parties moving in, kids, no kids, smoking, no smoking, gross income, because you want to make sure that they can pay their lease. So in turn, I can pay my portion of the mortgage. So these are restrictions that are important to consider. Another important restriction is your we talked about, Noam touched about on exit strategy, your sale of the property. So how a sale would work. Once again, it's typical where the other parties will get some kind of approval process. The other parties will have what's called first right of offer or first right of refusal. First right of offer essentially means if I want to sell it, the other party or parties have a right to purchase the property. So they may want to say, if I'm in the laneway home and I'm deciding to sell that share, the portion, the one of the other parties, perhaps someone who lives in the main house, or perhaps the main house is split into two, could have the right to purchase the property before it goes onto the market. And what's important there is setting out the procedure. I've seen agreements where it says parties have the first right to put an offer, but there's no procedure in place. So then the parties are arguing over how the procedure should work. The party buying the property wants a procedure that may result in the lower price, and the party selling may not. So a couple of years ago, where property assessments and appraisals weren't quite lining up. We're talking about like 2017, 18, when property prices were increasing on a weekly, daily basis. Me, someone who's selling the property, would want it to be appraised because it's likely going to be higher than the BC assessment value, and then vice versa for the owner who the party that would want to buy it. So it's really important not just to say you have these rights in these agreements. It's really important to also talk about the procedure and how things are going to work out. So that is a type of restriction you will talk about on the purchase, or sorry, on the sale. Another one that Noam touched about is, there's a process here of picking out who you're going to purchase this property from. So if I purchase a property with someone and then all of a sudden 6 months they want out, then if that's a concern of mine and I don't want to then have to go through the process of it being put up for sale and vetting other individuals, you could have what's called like a lockup clause, depending on the parties, whether this is something they want or not, because it could affect your liquidity of the property if you agree that you're not going to sell your share within a certain amount of time. Now, it's good idea to have some flexibility there. For example, if I get a new job, so you could have a carve out rate. If my new job is X amount of kilometers away, it allows me to get out of that lockup period. If this arrangement is, if none of the parties have kids, and that's part of the arrangement, the ownership, there's gonna be no kids. And then what if that changes? My partner and I, we have a child, we decide to adopt. So it's a good idea to discuss kind of a wide range. And then that's where someone like myself and Noam, who has experience in this, we know these questions to ask. And then what's really important here is what happens when someone passes away. So what are the restrictions that you're going to put in place in this agreement with respect to when someone passes away? Like I said, you tend to own these properties in tenants in common, meaning if I pass away, it doesn't pass over to the other owners of the property, it will fall into my estate. It is likely my estate doesn't want to keep the property, they'll want to sell it. So how will that process work? So it's important to touch base on that as well. And then an important one, which is very important, that is drafted properly, is if there is a divorce. So let's say I'm on title and I'm on title and I'm with another partner or two partners, and let's just say myself and Noam are on, we buy a house together. It's 2 suites. I'm in 1 suite, he's in the other. I have my partner move, and I'm sorry, I'm using partner. Let's just say, to ease sake, I'll use the word spouse. It's just so we don't confuse partner and spouse. So I have a spouse move in, whether common law, whether married. All of a sudden, we have the Family Law Act coming into play. If my spouse and we separate, how will that affect the ownership arrangement between myself and Noam? We want to make sure, he's going to make sure if I have a relationship breakdown, it's not going to affect his interest, and vice versa. So an example of this could be we are our mortgage is coming up and we're going to renew our mortgage. I have a relationship breakdown pursuant to the Family Law Act. It could be considered family property, and my spouse that I have a relationship breakdown could file a lien against the property. Now there's a lien against the property and we can't refinance the property. So we have an issue there. So it's important to have these clauses drafted appropriately that would protect the two parties from an incident like this, and what the mechanism would be in place if there was a relationship breakdown, what needs to be done contractually to ensure a lien can't be on the property, and what would be the requirements between myself and the person I own the property if I'm having someone move in with me. That could be late after 2 years, could be considered in us living in a marriage like relationship, and therefore having an interest under the property under the Family Law Act. So that's an important clause, an important section of these agreements, that needs to be really considered and very carefully drafted, going forward. And then going on to the next slide, which is just remedies. So how are disputes going to be resolved? And I've touched on this before. This is where the mechanisms are important. What is the process? It can be as simple as party A got to make the decision on this item last time. Party B gets to make the decision on this item. If it's an odd number, then it tends to be a little bit easier to come to remedies because you can just say the majority. So if there's 3 owners, 2/3 vote a certain way, that's how we're going to move forward. Worst case scenario, and this would be covered in the agreement, if you go through the mechanisms we've set out with respect to a dispute and you can't come to a resolution, then you may have a liquidation clause where one party could potentially have the right to buy out the other property. That's an extreme factor, but we tend to include those because it could be cheaper than going to court over over a disagreement. So that's why it's important to have the remedies and what happens if there's a breach. So we're not really disputing, but I'm not fulfilling a promise of mine. Perhaps I'm not paying my share of the mortgage. Perhaps we hired a gardener, I didn't pay my share. It could be a multitude of things. I just breached the agreement. So I continue parking in the wrong spot. I'm playing music. We said there's no Airbnb, and I disregarded that and decided, you know what, forget it. I'm going to Airbnb it out. What are you going to do about it? So if I breach the terms of the agreement, then we also would cover that off, and it's also a very important part of the agreement. It's important in these agreements. I've seen agreements where they will say, oh, it's a breach, and then that's it. It doesn't say, well, what happens when there's a breach? So that's another thing that we would work with you to figure out what would be reasonable in your situation here to what we call curing a breach. Everyone's situation is different. Everyone's purchase that they're making with the cohabitants that they're going to have is unique. And then that is why you need someone to work these things through you. I've had clients come forward with agreements they've downloaded off the internet, and I've yet to find one that we've been able to use. There's tends to be a lot of missing parts. Those are trying to be just standard boilerplate, and they tend to cause more problems than not. So those are just those are certain things to think about. These are just a broad overview of these agreements that I just wanted to touch base on. Hopefully get the mind going a little bit if you are entering into an agreement like this, considering it. And hopefully it kind of sparks the light onto, oh, these are items that we didn't think about, and we would need to think about X, Y, Z as well. So hopefully that was my goal there. I know that was a lot of information I kind of threw out at you, but that's why here, if anyone has any questions, I think we can open it up, and I'll do my best to answer any questions you may have.
Thank you so much, Daleep. Yes, please, if you have questions, unmute yourself or throw it in the chat, and you can share. I just want to kind of reiterate a few things that you talked about. The first one is, yeah, the exit strategy and timeline. People ask about that. a lot, and really, you create that plan for yourself. So whether it's an exclusion period or not, whether how long you have for the right to purchase from each other out, how long you have for the right to sell your share off to another one, and then how you sell each other out. So you create the plan so that you're both comfortable with the timeline, so that you feel like you both have the liquidity you need. You can get out within 6 to 9 months, and make your move to Ontario, but you also know you're not going to be just booted out next week. Oh, I'm going, see you later. I also just want to say that, this, Daleep, it sounds really scary when you talk about all of these things. And I think that's the point, is that if you deal with all the big stuff in advance, they don't come up as problems down the road. And you mentioned that, and I think it's key that if you don't address these things, little things become big. But if you spend the time in advance thinking about each of these issues, you never talk about them again. So I see the questions are starting to come in, so I'll stop talking.
And I'll just add on to that real quick. Yeah, so I know it sounds scary, but these agreements also not only bind you to what your obligation, but they provide a roadmap as well. So you have a system in place of how you're going to come to an arrangement. So they're helpful in that way. But I guess we just go in order.
Yeah, and I'll read them out so people can hear them. The first question we have here is, can you comment roughly on the cost of creating a detailed partnership agreement? And clearly it's going to be different based on your situation, but broadly, 2 to 3 owners sharing a home, needing to deal with all these questions about garbage and who's going to pay the bill and when. What are we asking from you? Or what are you asking from us?
Yeah, so you're looking typically for an agreement like this, about $1,500 is about where is usually on the lowest end. If we have everything in order, the parties know what they want, and there's limited back and forth. So we kind of say a first draft takes about that long. It's hard to give a solid quote, because typically what happens is I give the clients the agreement, and that's when the wheels start turning and they start thinking about, oh, we didn't really consider this option before, or we didn't consider this, and now we want XYZ, which complicates the agreements quite a bit. But typically you're at a starting point, budget around $1,500 in legal fees that you would say would be split amongst all the parties involved. So that's kind of the legal cost.
Yeah, I usually tell my clients to estimate about 2,000, just to two to 2,500, just to do it right. No reason to scrimp out on that. We've got the questions are piling up, so I'll just rush through them a little bit. Would be interested in hearing from your experience. There are a lot of things to consider. What comes up the most between co-owning partners? And I'll answer that first, just to say, in my experience, really the big question is the exit. Right. I mean, I think the ongoing living you can usually work out, but the big question is when someone wants to end it, where can you go there? So I don't know if that's what you're asking about. If you're asking about the daily living stuff, symmetrics, whatever this was, but that's the biggest one that I see people have issues with is the how do I get out? But Daleep, what else do you see come up a lot?
Yeah, that's definitely the biggest one, is how do I get out? The other items that come up is when you don't really stipulate exactly what your rights are to the unit. We've just over the last couple of years, because of Airbnb becoming so popular, that was definitely an issue that came up, and what the rights are with respect to that. But exit is the big one, because everyone's looking into, I'm buying this property, I hope it appreciates, and then perhaps I can upsize. So it's definitely exit is important.
Yeah, and I think the two things that get everyone scared, everyone loves the idea of co-ownership, and then they talk to their uncle or their financial planner, and the two things they say to them is, one, what if the person doesn't pay their mortgage? And two, what if you want to sell, or if they want to sell, and you're screwed? And again, that's where I think those are the two big questions that, if addressed well, aren't really that big a question. You protect yourself with your assets and with good planning. But yeah, those are the things we hear about most. And then people get scared and decide not to do this and go buy a 2-bedroom condo and squeeze themselves into a tiny box instead, when they could be living a better life if they just think a little more creatively.
Yeah, totally.
You mentioned some agreements might be asymmetric with respect to the use or ownership structure. How much difficulty does that cause? And I'll just explain this one. So sometimes you see where your ownership share is not necessarily directly reflective of your usage share. So somebody has more money and maybe owns 70%, and someone has a little less and owns 30%, but you actually use equal amounts or in different amounts. So there are structures where, each of you could pay rent, some portion of the fees and rent to the collective, and that's used to pay all the costs, and then people get their what they make. So you separate out the cost of living and the ownership structure from the ownership structure. So I think that's the question we're looking at here. There's a number of models of that. And does that make the legal agreement that much more difficult, Daleep?
No, not really. We can separate things out based on proportionate. So if it's proportionate equity that people put in, it's disproportionate. Or let's say one suite has 2 people in and the other one has 4. We can arrange the agreements so costs and things like that are set up proportionally. It doesn't really complicate things too much.
Great. Can you explain the difference between a partnership agreement and a strata agreement? Pros and cons of each. So I'll just start off by saying, if a property is stratified, then you will have strata bylaws and all sorts of strata agreements. If a strata can't be stratified, that's when you would create a different alternative legal agreement to go in that place. So clearly, if you can stratify a property, if you can get a duplex that is stratified, in the long run, it's co-ownership in that you co-own the land and the building as a whole together. But legally, you've got separate legal entities that you can finance separately and sell separately. We're talking about here primarily a situation where you don't have those same separate entities. Though we often see to people who buy land together, build together, and then the final product is stratified. So they start with co-ownership, they have a co-development agreement, and then the end product becomes a stratified agreement. Do you want to talk about this at all?
Yeah, so they're 2 very different things. A strata property will be governed by the Strata Property Act. If you have, an example I can give you is I had a client that built a duplex and then stratified it, and then once you stratify it, each unit is a separate legal unit. It has its own separate legal address, civic address, what's called parcel identifier number, PID. It's completely separate legally. It's looking at it conceptually. 2 strata units are almost as different as just 2 houses side by side. It's not quite, but just think of it that way, that they're quite separate. You have the Strata Property Act and you have the bylaws that are essentially the bylaws will kind of govern what we would have in this partnership agreement. But in that example, we're at a client who built a house as a duplex, stratified it, sold the other strata. Our bylaws were very tailored to their situation because it covered items that you typically wouldn't see in, like, for example, a tall high rise or a 6-unit strata. We talked about things such as they shared the yard, so how the strata used the common space, which was the yard. So they're just 2 very different entities that you're looking at.
Yeah. All right, going on here. Can you maybe touch base? In a joint tenancy or tenants in common, is it possible to link the value of each share to the rate of inflation versus the market value?
I'm not sure
I think what I think he's saying is, when you go to resell your share, can you have the agreement basically say you'll resell at a value of your purchase price plus 3% per year, and that becomes the value that you set for future resale. And if you put it in writing, you can do what you like, I'm assuming, correct?
You could do that. I wouldn't recommend that because property values don't increase with the rate of inflation. They're not correlated. The best way, if you're going to, so if you're not going to put it on the market, so if one partner is going to buy out the other, so one owner is going to buy out the other, then the easiest and best way is to get an appraisal done. Sometimes parties may not trust the other party, so we will say in the agreement, each party gets their own appraisal, and then you use the average of the two, and that's the fair market value. And so if I owned 50% of the house, then half of that appraisal would be what I would sell it for. If I own 30% of if my interest was only 30%, then I would just sell it for 30% of the appraisal. That's typically how we structure the mechanism to evaluate the value of the property.
And like
Hi,
anything,
can
you
I?
can always change an agreement with mutual consent. So
Yeah.
if your structure says you're going to get your appraisers, and the appraisers say your share is worth $1 million, but I can only afford 900,000. If you want to sell it to you for 900,000, then good on us.
Yeah, yeah. Sorry, I think someone had a question. Someone had jumped in there.
Yeah, it's Rohan here. I'm the one who asked the question about with regard to market value versus inflation rate. I've read about and I've talked to several people who are interested in developing co-housing groups together. But one of the things that came up was because in certain markets like Toronto, Vancouver, and other places, the development pressure, because the value of real estate is going up so fast, some people may be tempted to, want to bail out and cash in. And what it creates is it's a stability stress. And so a couple of people suggested in order to say, we trust each other, but we want something that's going to give us stable housing for the long period, so people aren't going to be tempted to bail out because, literally our property value will be doubling in 2.5 or 5 years. So we will voluntarily put into the agreement an inflation clause, or what our share value will increase for, in order so that we can have stable housing for us. That's where the question comes
Yeah,
from.
and that's definitely possible. So where we set out the mechanism of the example I gave of getting an appraisal, this mechanism of calculating based on an inflation rate or a predetermined percentage can be put into the agreement.
Okay.
All right,
yeah.
I'm going to keep moving this on because there are a lot of questions, but I just want to point out that that's the point. There's a lot of creative ways to do housing. And if we can, if you have a solution that works for you and your co-partners, the lawyer can draft you an agreement to make it work, 99.9% of the time. All right, can you maybe touch base on two couples purchasing a home where one member from each couple is related, like two siblings and their wives and children, which each member of the two couples own 25%. One vote per person will likely result in deadlock, and any other special considerations in a situation like that. So clearly you've talked about divorce and being prepared for that, but anything you can think of special for two siblings and their partners buying a home together?
Right. So, and this is with respect to deadlock, I'm guessing.
Yeah.
Yeah.
Deadlock or any special ownership structure you might choose in this case.
I'm just going to read it one more time.
You can read it yourself. I'll just say one thing, which is that it often depends where the money's coming from. A lot of times in this case, there's a fifth owner involved, and that's the bank of mom and dad of the two siblings. So just it can get even more complicated sometimes if they're the ones giving the money and they want to protect the interest so that if something happens, the property is going to their grandchildren and not to their wife and the wife's new husband. So you can get into all sorts of estate planning questions as well in a situation like this.
Yeah, you would have estate planning questions. With respect to the deadlock, depending on, you can have different procedures in place with respect to the gravity of what the issues that you're deadlocked on. So it could be as simple as a casting vote could be put in place for the parents if they're involved. Now, do the parents want to get involved? Do they want to get in between their two kids? That depends. So it just depends on the type of issue you're foreseeing that may come up and the deadlock could happen. So if it's, it could be as simple as party A on this issue gets the casting vote and party B gets if this decision is resulting in a cost less than X amount. Other than that, you can have a little bit more complicated process put in place to get rid of deadlock. But that's deadlock is an issue in all agreements when you have parties of 50-50. So even though here each couple has 25%, each party has 25% each. If each couple is going to vote the same, you have deadlock. It's the same as if we have a business and you have shareholders. This is a common issue just in all agreements on how to deal with deadlock. And if the deadlock is bad enough or it gets to that spot, it could be where a party gets the ability to buy another party out if you get to that level. Hopefully you don't.
So we have a bunch more questions, and we're going to keep
Yep.
going, Daleep, if you don't mind staying with us. But I just wanted to, for everyone who's there, if you have to leave, we totally understand. I wanted to point out that CoHo has a series of upcoming events. Some of them are the speaker series, like on February 2nd with City Councilor Christine Boyle in Vancouver, and on March 2nd, Collective Living with the founder of the Collective Housing Network. But we also have other types of sessions, the info sessions for more details on this on February 22nd and March 30th. And what we're doing right now is helping people who are looking for partners really form community. So we have 2 online events. Let's Make a Co-Home a Family Edition, January 23rd, and a Singles and Couples Edition on February 13th. So we encourage people to come to those, meet others who are interested, see if there's someone who has similar goals, similar aims, etc. And we have these guides on our website, resources. Please do go to our website, cohobc.com. And follow up with me or Daleep for one-on-one consultations to find out more about what your situation is and answer some stuff. But let's go back into the questions because there's really some good ones down here. What a wonderful presentation. Do you have a U.S. counterpart? So if you're talking about CoHo, CoHo is the local incarnation of what is a global movement. There's definitely, you hear a lot of articles coming out of San Francisco and LA. There's the groups in Toronto, there's groups in New Zealand and Australia. So we don't have direct relations with any of those, but I do know some of them broadly. So if you reach out to me, I can sort of connect you to where this I know is happening. But if you search it in your area, you may find a realtor or kind of some initiatives moving forward. And of course, Daleep, I don't know, you guys, where do you work?
So we're based out of Vancouver, but we have clients all over BC. We have a lawyer that works down in the US. So we can, I think someone had a question about do you have a US counterpart? So yeah, we have a lawyer in our firm that's licensed and is actually based in the US. So we can do this type of agreement, any kind of agreements that are based in the US. On this similar one, someone asked if we're licensed for Ontario, Nova Scotia. We do have a lawyer in the office that's called in the Ontario bar. So we do work out in Ontario. We don't have anyone based out in Nova Scotia, however, but if it's a commercial agreement, reviewing commercial terms, we could still, or terms relating to a co-ownership agreement, we could still review them, but we wouldn't have anyone in Nova Scotia, for example, to deal with the actual conveyance of a purchase or a sale.
Thank you. And if we use one of your specialists, we'd still get your expertise on the co-ownership stuff. You'd be advising them on the co-ownership stuff while they dealt with
Yeah,
the
exactly.
law.
Yeah, so I would work on the co-ownership aspect of it, and then we would engage, like, for example, the Ontario lawyer for just Ontario-based land title issues. That would be just specific to registration, how land title Things are registered. There's some procedures. Every province is different. And the same thing with the American Council. We would just speak not so much the items that we discussed in today's conversation would be handled by me. It would just be more technical items that really would just need to cover off with those lawyers specialized in those areas.
Great. And I guess we should throw in the disclaimer here, of course, that free legal advice is worth the paper it's written on. This is not legal advice that everyone needs to call you and hire you directly. And the same is true for me as a realtor, that you should call me and I should become your realtor, but until I'm your realtor, I'm not your realtor. But get those legal disclaimers aside. We got a list going on here, still moving forward. Can you explain some possibilities between a partner who is a Canadian permanent resident who will be in the residence and a U.S. foreign buyer who would be purchasing as an investment? And this is a challenge we hear a lot, particularly because of the foreign buyer's tax, the 20%. Yeah. So it's hard to justify a foreign investment unless you're looking at a 20-year timeline, if you have to clear that hurdle. But I'm assuming that if you co-own, the foreign buyer's tax is applicable to your foreign companion at their percentage of the property, and there's no way around that. Is that true?
That is true. As opposed to a way around that, there is not really. You can, depending on the relationship between the parties, it could be possible to structure the purchase in a way that could minimize the foreign buyer tax. But there's pros and cons, like anything, to such a structure. So it's a very technical question. You got to get cross-border tax advice. So you'll need to get an accountant involved that has experience with US and Canadian and the treaties between the two countries. With respect to the foreign tax, buyer tax, and how we would structure things, there's no one answer. There's potential to do some planning, but it depends on your individual situation.
Okay. Is there a typical maximum number of people that you would do a co-ownership partnership agreement for? Well, for example, with a collective home, would 5 or 6 people, 1 per bedroom, be fine? What about 10 to 12 owning a fourplex in a similar but room style agreement? And again, before I turn over to you, I would just say, I think from my understanding, the challenge here is not the agreement, the legal agreement. You can deal with that technically, but it's going to be your financing and any zoning bylaws you might be coming up against with regards to unrelated adults living in a property.
Yeah, zoning. And then another issue that, as opposed to drafting the agreement, is 5, 6, 10, 12 people all on the same board with respect to the terms, like items that I had listed. So it's possible. We've done agreements with 5, 6. It's common. We did one recently where a lot of houses in the Kitsilano area, where these tall, skinny houses are actually been turned into apartments, essentially, but they're not stratified. It's just one house. So we did a purchase with multiple buyers for this property. So we were able to do it. It wasn't that much more difficult because they had a good idea of how they wanted the terms of the agreement to be. But the more numbers you have in an agreement, the drafting's fine. Coming up with how clauses are going to be, it's the actual negotiation between all the different parties. So if you have 10 buyers, you have 10 parties who have their own interests that they also are looking out for. And so that could make things complicated, not from a legal drafting perspective and then coming to actually figuring out what the agreement's going to say, but it's actually getting to that stage of where everyone's on the same page.
And to that point, I'm assuming when you start getting too many names, you stop putting everyone on title and you start creating a company and putting it in company names, creating a share structure. And you, of course, can help people through that whole process and help decide when it makes sense to go everyone on title and when it makes sense to go corporate.
Yeah, so we have a family. It was, I think, 4 or 5 siblings purchased a vacation home. And so it's a little bit different here. but it's the same premise. For that structure, we ended up incorporating, and you have what's a shareholders agreement, but it covers the same type of issues. So you can do a corporation. So if you do have 10 to 12 people, you may want to incorporate. And here you're kind of, so before there were strata, as like Noam had highlighted, you would own a percentage in the company, which would be attributed to usually your square footage. There still are properties in Vancouver like that. So you would do a corporation. Another item that we've done in the past is not actually everyone goes on title. You do what's called a nominee agreement, where you only have perhaps 2-3 of the individuals on title, and then you have a nominee agreement with all the actual true beneficial owners. There's a legal owner and beneficial owner. And I won't go into too much details about it, but it's just two different ways of owning property. But the 3 people on title are the legal owners, and then the 3 people and everyone else are all the beneficial owners. And essentially the nominees who are on title come into an agreement saying they will do whatever all the actual beneficial owners say that they are to do with the property. So that's another way. If you don't want to incorporate, that is another strategy that we've used.
Great. Is there a resource list of questions, maybe with typical solutions for some items that a group of people can reference to begin the discussion before coming to a lawyer? So I'll just say that CoHo, as on our website, coho.com, cohobc.com, excuse me, /resources. Again, we have this guide. This guide has a page with a list of 10 kind of main things to think about. And there's also some articles from Daleep's law firm and from other law firms about this question. They tend to be a little bit not as in depth as you certainly just went into. Is there a more in-depth checklist that someone can start with?
I was gonna say your website. That's where I've directed people to before. I don't know of a checklist online. I've never used one myself. But yeah, I mean, I would start with your website. I think that's a great resource for anyone.
Okay, thank you. All right, they're still going here. Thank you all for your thank yous, by the way, that are coming up on the chat. We really appreciate that. Due to how much impact the partnership agreement and exit clause has on buying a home together, do you have any examples / sample partnership agreements that can be viewed for ideas and concepts to help people figure out if it'll work in their case? So do you have a sample one that you're willing to share? I mean, the problem with and the lawyers don't like to share out their legal stuff because people use it without understanding it.
Yeah, we don't really have sample agreements. We have agreements that we've created for clients, but then it has all our clients' information in it. Typically, in a consultation with a client, we will walk them through the exit clauses that are relevant to their situation and their goals. So I've never really provided a list of clauses, how they work, because I don't have a list. It's usually just from experience. These agreements are tailored to each individual client. So usually we come up with the options, provide a pros and cons of each one after we've had a consultation and get an idea of what your goals are and what you're trying to achieve.
Great. Okay, so one last question that's coming here. In a partnership agreement where at least one person is a first-time buyer, is there a way to leverage this credit even if others have bought before? And of course, this is up to a maximum of $525,000, which doesn't take you far in Metro Vancouver, but certainly can get you in the market, and or when out of the later in the province can do a lot more. So similar to the American question, I guess. Are there ways of getting more of the first-time home buyer discount to save on the taxes?
You then what you would do is that nominee example that I used, you could have the first-time home buyer be the individual registered on title, who would then enter into a nominee agreement with the actual true beneficial owners. But there's a risk with these agreements. The person on title has a lot of power, and if they don't, they say, well, you know, I know I signed that agreement, but I don't care. Now it's only as good as the amount of money you're willing to spend to enforce that agreement. So it's possible, but it might not be worth the risk, especially if it's just the one owner. Because if you want a mortgage, you want to sell, anything with a property, that individual needs, you need their signature. Now there are other ways around it with power of attorneys, but once again, it's a very technical question and very it's very catered towards that one situation that we need to work with you.
Great. So let's see what we got here. I've engaged a lawyer from Segev before, and she was excellent. I'm sure you are too, Daleep. Thank you, Diane, for your testimonial to Segev as an institution. Can a 5% down payment work for agreements like this, or typically only 20% down? And I'll just give my answer first again, which is that from my understanding, I think 5% is fine, but you want to figure out how you're protecting your own interest and what happens if the market shifts, etc. So particularly when you're on the hook for the entire mortgage, if someone disappears, you kind of want to know you have enough of a down payment that if the market shifts 10% and your person decides to bail on you, you are protected in your asset class, and the agreement will only protect you as far as the asset value protects you as well. So that's my only concern as a realtor in this situation, is you want to have enough of a down payment that if situations shift and the person jumps out, your partnership agreement can kick in and protect your interest. Is there any other concerns that you see here with that?
No, I think you pretty much nailed it there. You're with 5% down, you know, with especially the 20% down, there's more of an incentive, because there's more equity in the property for the individuals in the agreement to adhere to it, and like you said, not skip out. So I don't see why you can't do the 5% down payment, but it might strategically, it might not be the best way to go forward.
So that's all the questions we have in the chat. If anyone has any more they want to throw in, please do. Otherwise, I really want to thank everyone for joining us today and for some really good questions. And of course, a big thank you to Daleep for a very thorough and very engaging presentation. And I really want to encourage everyone, you will now be added to the CoHo email list. Please stay on, although if you choose to subscribe, we'll understand. And do come to one of our 6 upcoming events, or many of them. Come to our website, and then do reach out to me, myself, or Daleep to talk about your particular situation and figure out how to take advantage of this exciting hack, exciting opportunity to create better affordability, better community, better housing, and particularly in a time like this when we're stuck in our homes and we're stuck with our bubbles, and uncertain economic future. I think this is a really viable and valuable housing form, and I'd love to help people achieve it for themselves. And I'm delighted to hear that that Daleep, and I've met his boss, I guess, colleague Alon Segev, that they've really given this serious thought and experience and understand the ins and outs of what it takes to protect people, my clients, to protect folks as they go through this process. So thank you all very much. Do feel free to follow up. CoHoBC.com, Noam at NoamDolgin.com, DLJ@Segev.ca. And again, thank you and have a good night. And if you have any last questions, we'll be on for another moment or so. So thank you again.
Thank you, everyone.